And is it Balle or Balle or?
Balle.
Balle?
Yeah.
All right. Balle versus Balle, case D08392854D. Counsel, if you could state your appearances for the record.
Neil Mullins, bar number 3544, with and on behalf of Cynthia Balle.
Andrew Taylor, bar number 8688, with and on behalf of Mr. Balle.
Now, Mr. Mullins, do we have a hearing set for you to withdraw, or?
Both set now. One's at 2 and one's at 2:30, and I was going to, if I could, combine both issues and then ask for the withdrawal at the end of the hearing so she at least has representation on all the issues.
Okay, so that was my question. You want to withdraw now, or?
I'll wait till the end of the hearing.
Okay. All right. Did you both get a copy of the interview?
Yes.
All right. Do you have anything that you wish to anything you wish to direct the court's attention to in the interview, or anything you need to address?
Yeah, just very briefly, Your Honor, if you, and whether you did or not doesn't make a difference, if you go back to the motions that were in front of you before we did the interview, we knew that there were going to be negative comments about Mom in the interview, and she's alleged all along, and we believe some of this interview helps, that on an ongoing basis, these children are being coached. She never had an issue with these children having a problem with her until she filed a divorce proceeding. And once she did, there's been cops involved, there's been disrespect against her mom, who's a grandparent, there's been calls at night during her visitation. There's constant communication between Dad and Petra, the oldest one, who she ended up having even a physical issue with at one point that interferes with it. So we absolutely knew that their independency of this case, while this contentious custody case is going on, that those children are going to have some negative comments to make about their mom. So we've asked for evaluations, we've asked for interviews and stuff like that, but because of the financial issues that are involved in this, there hasn't been that opportunity. And I got to tell you, we both came to this court hearing last time. There were tons of issues that we could have argued with, but Your Honor spent so much time going through the pleadings that we had to limit it to, and understandably, limit it to what's going on. And the unfortunate thing is this is a family that, if there's not some intervention, in my opinion and my client's opinion, by someone that can see through some of the turmoil the kids are in because of the changes.
Counsel, at this point in time, I'm willing to appoint an evaluator.
That would be great. And then the second thing that we wanted to address, Your Honor, is the flagrant, and I mean flagrant, violation of the orders. So one little small portion of this presentation I'm making to you has to do with a point that I tried to make the last hearing, and you didn't let me, and I'm not saying you were wrong with it, but the bottom line is there has been 3 tax returns now instead of just 2 that are in front of me. And here's what's happening. And if you just bear with me for a second, it'll just take 2 minutes, and then you'll be able to know how to address
just a second.
Other stuff.
Hurry up with it.
In 2005, this gentleman's gross income from his chiropractic business that he does not work full-time on, he only works a couple hours a day on it, generated $443,000 in gross income, $292,000 in net income. He then makes a voluntary investment in a bogus business called Digital Dojo. He takes a loss of $159,000 in 2005 for the business. The following year, he makes $417 gross, $295 net, just $3,000 higher, and then takes a $121,000 loss from that business. The following year, which is last year, his tax return that he wants my client to sign, and she won't because it's outright fraud to do it. He has a $323,000 income, $255 net, and then takes 2 big deductions. One, $53,000 from this Digital Dojo business, which he doesn't run and is not involved with, and another $57,000, and here's the big one, for a property that he claims he sold in his tax return but was foreclosed upon. You can't take a deduction of $57,000 for the difference in the sales price of a piece of property and not tell the IRS that it wasn't sold for the loss, it was foreclosed upon. Because as Your Honor knows, if you foreclose on a piece of property...
I don't know. You're talking
Well-
about taxes, then
Well, when the
I,
IRS forecloses on a
I'm
piece of...
blissfully ignorant when it comes to
When a bank
taxes.
forecloses on a piece of property,
They get a judgment, they charge it off, and they
well,
write
the
it off.
IRS has the right to say that the amount of money that was
Okay.
forgiven on a loan is income. The
So-
bottom line is, he's got affidavits in front of you saying that his income net is about $123,000 a year. Now, you can liken this to me tomorrow, having an income of $300,000, choosing to invest $150 of it a year in IBM. If I lose the investment, I don't get to come to court in divorce case in front of Judge Potter and say, I make $300,000 a year, and last year I invested $150 and lost it. So therefore, I want my child support to be based upon, and my alimony to be based upon this amount of
Well,
money.
have you gotten any documents regarding this business at all?
I have the tax returns to show it.
For the
We have
for
Digital
Digital
Dojo.
Dojo.
This is what he did with Digital Dojo. He has a partner. He bought a house and let the partner live in the house, and then he paid all of the partner's expenses. It wasn't, I mean, I'm sure there was equipment purchased and stuff like that, but the bottom line is these people were living in a house rent-free, and then he was taking the money that he was paying the rent for and claiming that that's a loss for the business, and at the same time telling the IRS then when he gets foreclosed upon for failure to make the payments that he gets a deduction for it. The point of the matter is this, and I'm done with the financial analysis now. The point of the matter is you took his representations made in his AFC that he makes $144,000 a year at the last hearing, and then you issued an order about how he had to pay her $6,000 some odd dollars a month for child support and alimony, and you made an order for him that he had to pay $2,500 a month for legal fees that he didn't pay. Now, my legal fees to date, after getting paid a $5,000 retainer or something like that back in the early part of the summer, are at $11,000. If I get an order from you today that he has to pay my office directly, and I mean immediately, the $7,500 that should have already been paid, I'll reduce the balance of the bill against Cynthia down to the $11,000, and I'm done. But he also ought to have repercussions for violating that court order with knowledge now for more than several weeks that this matter was coming, knowing that his single mother, wife, is trying to represent herself in court with the kind of financial analysis you can imagine a lawyer has to go through to get this done. That she doesn't have the
Bottom
resources
line,
to do.
Mr. Mullins, what specifically do you want me to do today?
It's easy. I want you to address...
It would
the
be
issue.
easy if you would tell me
All right.
specifically
I want
what
you
it
to-
is.
I want you to ask him in court why that money wasn't paid and find out why this lady...
What money?
$7,500 attorney fees you ordered.
Okay.
38. Now here's the other thing. I
No,
prepared.
no. Don't backtrack on me. We were making some progress. You want me to ask him why haven't you paid $7,500 in attorney's fees?
You want me to answer?
Yeah.
No, I don't have it.
Okay. Thanks. What's
I
next?
don't have it.
All right. I guess that's it. You
That's
know
his
what's going on.
answer.
You've got the
Truth.
Okay, but you're not asking me to modify any of the previously set
no, your
amounts.
financial orders are fine.
Okay.
But I want you to look at those.
Well, why the heck am I listening to you for 15 minutes? That's time I won't get
Well, Your Honor,
back.
you just
No,
say,
I'm-
okay,
I'm-
but she has no lawyer.
No.
The case goes on. She has no representation.
I
and
got
gets
you.
away with all this.
I got you. So the attorney's fees.
Now, the last thing is, regarding the kids, the custody situation, they didn't succeed in getting a parenting plan signed. At some points, they thought they had that worked out, but they need a holiday schedule so that when they come back to court in front of you, Your Honor,
All right,
they'll have that done. Thank you.
counsel, briefly.
Judge, I will be brief. On the family court mediation, I want to draw your attention to page 2, paragraph 1, 2, 3, paragraph 4. It's very clear that the children want actually the time to be reversed rather than spending the bulk of their time with their mother. They want to spend time with their father. That's the first point. Second point,
Why don't you tell me why they want to spend the time with the father and show me some factor in there that leads me to a best interest analysis?
well, when the
Because
kids...
the only factor I got out of the whole thing was fun, and fun's not a factor for best interest.
It's not. Recognizing they do enjoy having spent time with their father. When they're with him, he does their homework with them. He spends time with them. He takes care of his kids as he should. apparently, you know, if you look at,
Does it say homework and stuff in there? Because let's see, I got Las Vegas, California, play games, go to movies, watch videos. We do nothing fun with mom.
He's got him on the weekends. She hasn't.
I only have them on the weekends, yeah.
Okay, so all right,
but,
all right.
but he does
Tough
do
to-
homework with him, Judge, and he does do things that a father should. And that being said, you know, he works more than 2 hours a day at his business. He works a substantial amount of time. That being said, he does have time he can spend with them. He could spend, you know, more than just a weekend with his kids. They clearly want more time, and he has the time he can spend with them.
She would love a thing where they share weekends and share some of the weekday responsibilities, if that's what he'd like, because right now she only sees them for the homework days during the week because he's got every weekend.
Well, do we need a PhD for our outsourced evaluation on this one?
I would think he would.
Your client's gonna have to pay for half of it.
As long as he's going to, the court's going to honor the awards regarding
Yeah.
the financial orders you've
I'm
made.
not modifying any of the financial
Judge,
orders today.
Do we need a PhD if both parties want to spend?
Well, that's what I'm saying. Do we need a PhD? We can save you some money and
You want
send
to
you
do a
to.
marriage family therapist? That's fine.
Because I'm looking at.
Because if the plaintiff is going to school, the plaintiff is spending time away from the kids. She wants to do her thing.
Look, I'm looking to try and save you some money. I'm looking at Jack Cathy or Donna Gusnell. Deborah Roberts. Anybody have any preference?
The first and third one you just mentioned,
Equal Wyford, Donna Wilburn. What?
3 of the 4 are fine. I'm not a preference of Donna Gosnell, but the other 3 are fine. Either one of the other 3 are fine.
Paul Wolkin.
Paul Wolkin.
Never mind. He's.
But Jack Cathy,
No preference,
Deborah
Judge.
Roberts, or
Let's go with Jack Cathy.
that's fine.
I like his reports. So I'll need a outsource referral. I'm not sure where Sherry's got them stashed.
Now, Judge, we do have a proposed visitation schedule if they would be interested in entertaining it.
Well, you can talk about it amongst yourselves while I fill this out really quick. Then, Brad, if you can give them each my standard holiday schedule.
Oh, yeah.
It's not a, he didn't agree to You want what? Say it again?
Oh, he did. Thank you.
He's going to have you tell it to Donna Gosnell, who's going to report back to him.
Jack Cathy.
Jack Cathy, I'm sorry. What's that?
Monday, Tuesday.
I thought Donna was the one you said you didn't.
During the pendency till you come back, his offer is, would you consider doing Monday, Tuesday, and Wednesday, Thursday, weekend alternates until you come back to court? We would have the weekends stay where they are.
They're looking at it.
Problem
With the baby, no way.
is she could see half the week when the issue is still contested. He backs a day off and shows you.
One day out?
No. I don't think he did, dude.
What if
No.
Look, have either of you guys read the Rivero case yet from the Supreme Court
Regarding schooling, is that the one?
regarding joint physical custody?
Rivero,
Yeah. Let me elucidate you.
how recently was it?
Very recent, October 30th. The Supreme Court has now defined joint physical custody. They accepted the definition that exists in Missouri that states joint physical custody means an order awarding each of the parents significant but not necessarily equal periods of time during which a child resides with or is under the care and supervision of each parent. Joint physical custody shall be shared by the parents in such a way as to assure the child of frequent, continuing, and meaningful contact with both parents.
How do you reconcile that with primary then? I don't even know how to do
Well, what you have is you have a primary and a secondary, but it also has a component in it that modifies child support that you can take a look at and
I will.
takes into account the time weighting factors. with the new definition, I don't know that it doesn't matter how we count up the hours, is all I'm saying. You know, we used to fight not to have a 50-50, and now at this point in time, with the definition we've got, I'm not sure that we need to worry about hours in the day and days of the week as much anymore.
I'm going to whisper to council for just a second. It could help us.
Well, I need to call another case here fairly quickly, guys.
Plus every other weekend.
No.
We have
I want
the
the same
return
amount
date.
of time as her. I'm done. Same amount of time as her.
Well, I mean,
Nope. I want the same time. Okay? So don't even bother.
I'm not talking about permanent. I'm talking about
I'm talking about now.
Put it on their
I
referral.
want the
and
same amount of
let me
time
know
as
what
her,
it
if
is.
not more time than her, because that's what my kids want.
Yeah, that's something else.
Do I do all
I don't think not in an outsourced.
What we're talking about now is trying to change what the judge is ordering, which is just weekends.
120.
If you'll give us,
I'd rather just have the weekends in.
okay,
You know what I'm saying?
all right.
The kids want to be with me, dude, not her. They can't stand
I know.
her, dude. Or her. They hate her.
I know, but I mean, the
That's all
point
it
is,
those issues.
right now, they're willing to agree.
But that's why he's sending you to Jack Cathy. She wants to make a comment to you, Your Honor.
Trust
I
me
know.
on this.
Oh, I know.
I'm not scared. I'm not hiding nothing.
Your
I'm
Honor,
not scared.
You gotta stand.
there are just a few things that I think that you should know about, and this is very recent. The baby's birthday was the 25th of October, which fell on a Saturday, and the temporary order said that he gets them from Friday afternoon till Monday morning after school. I had called and requested some time with the baby for a cake with friends on the Monday, and he emailed me that he would have to deny my request, and he would not let me see the baby on his birthday.
Okay, thanks.
He's
Not true. I said she could.
Stop!
the second one.
Stop, please, just stop. I mean, go file a TPO, go file a criminal case, file the appropriate motion. I believe in parenting. I believe that children do what you tell them to do. Children don't drive the family, okay? So the fact that I got 3 kids telling me, and you think I'm going to, just because they tell me that they want to spend more time with you, I'm going to order it, that's crazy. That's crazy. Because I might be an old-fashioned hardcore parent, but I'll be damned. I'm going to let some 13, especially a 13-year-old girl, tell me how she's going to raise herself? Not happening. Not close. That better be one special 13-year-old before I'm going to take just her whim into consideration. Now, these kids could have cited relevant factors that relate to determining the best interests of a child, which would indicate maturity and an understanding of the situation, then I'm more than happy to listen to them. But like I said, all I got out of this report, all I got out of this interview is fun, no fun. But that's not all. I mean, there are a couple things in there, ma'am, that you need to be very cognizant of. You cannot badmouth Dad when you're gabbing with your sister, your mother, your friends, anybody else. Even when the kids aren't there, it shouldn't cross your lips. Write it in a journal. Keep the journal under lock and key. Do not let your children have access to court records or documents. Neither one of you should be attempting to coach them. We've given you the outsourced evaluation. At this point in time, I think an expansion of the visitation may be warranted, but you know, I'm not entirely sure how to make that work. And so, you know, Mr. Anderson Taylor, I'm not sure when is your client available? Besides, I'm giving him the weekends, which is all of his apparent available free time.
Your Honor, truthfully, I'm
Or is he only working? If he's, I mean, they claim he's only working a couple
No,
hours a day
no.
at the things.
No,
so-
the fact is that I'm only in my office a couple hours a day, but I do marketing for my office and management. So I'm not in the office. Like I don't physically have to be there. I work 24/7.
Well, then you definitely don't need to have more time. If you're working 24/7.
No, I'm saying I could be with my kids because I work on my phone.
You can't have it both ways.
I'm saying
You
I'm
can't-
available
No,
to
wait,
you.
wait. Time out. Here's another parenting nugget from Judge Potter. Multitasking doesn't work with kids. You're either working or you're parenting. I try and do both, and it slows the work down. That's why you're working 24 hours a day, because you're trying to multitask. How you work when you got kids running under?
Well, it's not that I have work to do 24
How
hours
do
a
you
day.
pay
it's that-
attention to your kids when you're working? It doesn't work that way.
Judge, that being said, I think he can
All
take some...
prior orders will remain in full force and effect. The $7,500 that was awarded, Mr. Mullins, that's reduced to judgment, subject to all interest and penalties, collectible by any lawful means. Put liens against the property, do whatever you need to do.
The property's gone. I was hoping you're going to make it
I-
directly against
There's
him.
probably, he's probably got a cash register or something in the safe in the office. Get the sheriff down there and seize it.
Okay, Your Honor, so I'm
Take his car. I think they've got some paid off assets. There might be an x-ray machine in there.
Right now, what I have is that the judgment is against my client because I don't have a remedy against him. Now that you're making an order that I can go directly with him, I'll submit a second order on that issue to Your Honor. But for now,
He's the one that owes the money.
okay.
Didn't wasn't that my prior order? Was it he owed you money?
You ordered preliminary attorney fees
There's a court case. Hold on a second. We'll talk
in
about it.
general without saying it that way. But now I can interpret it that way and submit a second order, and then I'll have you sign that against him in judgment.
Yeah, those
And apparently he's got a motion to set aside that in front of you that I'm not going to be here for. I think we're done.
we're done.
Are we-